All right. Good morning, everybody. Welcome to our town hall for notaries public. My name is Michael Schlein. I'm the division administrator of the Charities and Legal Services Division here at the Secretary of State's office. And during today's town hall, we're going to talk about basically how to avoid complaints, top 10 mistakes that notaries make when they're notarizing something. Right? Nobody wants to be the subject of a complaint or something done wrong. And so we're going to talk about these little pitfalls that folks run into when they notarize documents so that you can avoid them and never be the subject of a complaint that we get, and helps you do a good job as a notary public. So as indicated in the email notification about today's town hall, it's being recorded. A link to that recording will be available on the Secretary of State's website under the Notary tab. It's usually posted within a few days of this town hall. So if you miss something, or you want to rewatch, feel free, and it'll be posted within a few days on our website. By choosing to join this town hall, you are consenting to the recording that is occurring as a part of this town hall. The content and presentation provided is for informational purposes only, and it is not intended to be legal advice. I'm not an attorney, and even if I was, I'm not anyone's attorney here. So again, for informational purposes only, not legal advice. In response to emails received, attendance is not required. Folks ask us, is this a requirement of being a notary? No, you do not have to attend these town halls. They are done as a matter of outreach and just conversation and sharing information about things that we're frequently asked about, topics that feel maybe we should touch on a little more in depth. So this town hall is also not the course of study or a substitute for the course of study that is required for you to renew your notary commission with the law that became effective October 1st, 2021. The town hall, it's just an outreach to educate Maryland's notary publics, notaries public, and those interested in being a notary public. Times reserved at the end for questions. You may find your questions are answered as the presentation progresses. If you have questions, place them in the chat box. Do you want to say, though, in order to prevent confusion about the source of the response, please don't answer any questions in the chat box. We have our notary officers on hand to do that. Carrie Ann and Tarshia do a great job of answering those questions as they come up in the chat box. If we notice frequent themes of those questions, we tend to read them off at the end too, so we can explain it or talk about it a little more in depth. So place your questions as you have them in the chat box. You'll find that some of them are answered as we're going. Some of them may be saved for the end. Some may be both, right? And but don't answer questions. Appreciate the good nature of folks trying to help out, but let our notary officer or myself answer those questions. We've had a few times here in the history of these town halls where folks write answers in the chat box and they're just totally wrong answers. Well intended, but wrong. So we want to get good information out to everybody. So questions there, we'll answer them. And we'll hold some time for questions at the end as well. And and again, our notary officers will announce those questions at the end as well. So a lot of frequent themes that we see, we'll make sure we spend some time and talk more about them. If you have questions about title insurance producers and independent contractors, otherwise known as TIPICs, be sure to refer to our town hall that's on our website. From February 21st, 2023, we had a whole town hall done between us and the Maryland Insurance Administration to try to cover what is a TIPIC and what are the requirements for those title insurance producers, often referred to as a notary signing agent. We do not license title insurance producers. The Maryland Insurance Administration does, so we can't really field questions about those. That's probably one of our most frequently asked questions is trying to get information about title insurance producing and how to do that. So make sure you watch that town hall and direct those questions to the Maryland Insurance Administration. And again, a recording of today's call will be posted on our website, and the content and presentation provided is for informational purposes only. And as we begin, I think everybody's done it. If you'd like to keep your camera on, feel free. Please mute your microphone to eliminate some of that background noise that happens sometimes on these virtual meetings. So without further ado, I'm going to get started. Carrie Ann, did I miss anything in that opening?
Sorry, I was on mute.
It's okay. Hey, you know, leave it to me to ask you a question after telling to mute yourself. So,
so yeah, no, I think you covered it all.
All right, ready to roll then. So again, top 10 complaints, things that we see that notaries are doing out there that they should not be doing. And I would say that this is especially good. Even if you've been a notary for a long time, a lot of things changed when the laws changed on October 1st, 2020. So some of this may sound new, and that's because as of almost 3 years ago now, hard to believe where that time went. But yeah, 5 days from now is October 1st, right? So almost 3 full years of a lot of wholesale changes in notary law. First mistake has less to do with notarizing and more to just do with getting commissioned. And this happens a lot, and that's why we're going to lead with it, right? Everybody's really tuned in right now. Failing to pick up one's commission, right? Just basic commissioning errors that happen in the process of becoming a notary or renewing your notary commission. Failure to pick up your commission and be sworn in at the clerk of the court within 30 days of the issuance of that commission. Need to get sworn in within 30 days. We issue that commission. You get a notification from our system by email, sends you a few reminders telling you how you had 30 days to go get it. Make sure you get it. Your commission's issued. The moment that email comes to you is the moment the clerk of the circuit court has that commission in the system and is able to swear you in. You don't have to wait 7 to 10 days to go get sworn in anymore. You go right away, right? You don't have time to forget anymore. You remember, you get that email, it's the moment you can go get sworn in. It's all done through our notary system now, and it's in their queue. And as a matter of fact, now when you go to the courthouse and get sworn in, moving forward here, your commission is going to get sent to you by email. As soon as the clerk plugs in your qualification date, you're going to get an electronic copy of your commission, so you can have it, save it to your computer, your inbox, whatever you want to do. But it's all electronic now. That is, they ask someone else to go get that commission. Can't do that. You yourself are the notary. So you yourself need to go get your notary commission with your name on it. Nobody else can go take the oath of office and sign the test book at the clerk's office. So mistake number one, really just things with getting your commission. If you don't get your commission within 30 days, that commission gets revoked. You have to reapply. Enjoy it just as much as folks that go through it don't enjoy it. So don't let that happen. And if you know there's a problem, you're not going to be able to get down there within 30 days to get in, reach out to us and let us know. Be proactive. We could kind of hold on to it and issue it later, so you have 30 days to go get it. But you got to let us know that in advance. Don't call 2, 3, 4, 5 months after the commission's been issued. At that point, it's too late, right? Get down there within 30 days, and if it's not going to be possible, let us know in advance. Stuff that we do when we notarize here, failure to identify the signer. The notary must always identify a person requesting a notarial act. I know this probably sounds very obvious, but you'd be surprised how many times this doesn't happen. And that can lead to all kinds of problems, right? You're like the front line of defense on forgery and fraud. Your job is to identify the people requesting the notarial act. And you must be able to identify that person requesting the notarial act each and every time. You must obtain identification prior to performing the notarial act. There's a few types of identification that you can use, and that includes government issued photo ID, like a passport or driver's license, consular identification, government issued non-driver ID cards. So if you don't have a driver's license, you can still go to the MVA and get a non-driver ID card. And another form of government ID issued containing signature and photo of the individual and that is satisfactory to the notary public. If I'm a notary public and I don't know the person coming before me, I'm requiring a driver's license, non-driver ID, or passport, right? Those are the things that I know what they look like, and they all have your signature and your photo. So are there other government IDs you can take? Yes, as long as they have a signature and a photo, and you, the notary, find it satisfactory. If you're going to ask me for an example, you're going to trip me up because I can't think of any off the top of my head that aren't driver's license, non-driver IDs, and passports that have a signature and a photo. I have a state issued ID for work. It has my photo, doesn't have my signature, so it can't be used. Personal knowledge is another form of identification. That's personal knowledge of the identity of the individual personally appearing before the notary. If the individual is personally known to the notary through dealings sufficient to provide a reasonable certainty that the individual has the identity claimed. That's a mouthful, but really, do you know them? Do you know them? Know them? You know people, but do you know them? Know them? You need to have sufficient dealings to provide certainty that the individual has the identity claimed. You really know somebody, not, oh, I met you once. I don't, you don't know them very well. Bump into somebody. People use nicknames or assume names all the time. Identify people you don't know. Personal knowledge, you got to really know them. Sufficient dealings to provide reasonable certainty is the key phrase there for personal knowledge. The other form of identification you can use is credible witness. The notary may identify an individual by means of verification on oath or affirmation of a credible witness who is personally appearing before the notary and known to the notary, or whom the notary can identify on basis of a passport, driver's license, consular ID, non-driver identification card. A credible witness, you will see more kind of as we get here in identifying a minor, right? Not everybody has a driver's license or a non-driver ID card. So if that happens, you may need to find yourself in a situation where you have to use somebody else that you can identify, who can identify that person and that they are who they say they are. So you see this more on identifying a minor because many of them don't have IDs. But I would say that your best methods are government issued ID and personal knowledge. And if I giving an example that if I drive to you to get something notarized, and I say, I don't have a government issued photo ID. I got bigger problems with that document notarized right now, driving around without one, right? So thinking of those situations where somebody really should have a government issued identification that you can use, or if you know them, obviously personal knowledge. Credible witness is kind of that you don't know them. You can't use government issued identification for one reason or another, so you have credible witness. Third mistake here, we get into overcharging errors. The notary fee is now $6 per notarial act. The fee is the charge for each signature that a notary notarizes. I'm trying to get my office light to turn back on there. There we go. Additional copies of the same document, a notary may receive $3 for each signature notarized. The notary may not demand and receive more than $2 if they're making a photocopy. Notaries allowed to charge to travel to perform a notarization. So you come to me to notarize something. There are some travel fees that a notary can charge. I'm going to go over in a second. Oftentimes, notaries that travel call themselves mobile notaries. This is not a separate licensing category. Any notary can travel to the Notarial Act. Just because somebody does or doesn't call themselves a mobile notary doesn't mean they cannot travel or they can travel. It's a term used to describe notaries that go places and notarize things, but it's not a legal term. You're not going to find it in the law. It's just a term folks use. So don't get too hung up on folks calling themselves mobile notaries. Again, it's a term that's used by those folks that are willing to travel places, but it's not a term you're going to find in the law or where there's any legal ramification of calling somebody a mobile notary. For traveling, though, notaries may demand and receive reimbursement at the IRS prevailing rate for business travel and a travel fee not to exceed $5. So you're traveling to meet a notarize, you can charge a $5 base fee to travel. You can charge mileage to travel to me, and you can charge up to $6 for the Notarial Act. So $5 plus mileage plus $6 per Notarial Act, or these other charges there up on the first two bullet points. It's not a $5 fee for travel. It's $5 plus mileage plus Notarial Acts if you're traveling. Remote Notarial Acts are $25 per Notarial Act, per remote Notarial Act, I should say. Remote Notarial Acts require a specific technology. We'll have a town hall specific to remote notarizations later this year. You'll see that list of upcoming town halls in your email invitation that told you to come to this one. So take a peek if you're interested in more information about that. There's also a recording of last year's remote notary town hall on the notary page of our website that you can look at as well. If you want to view that more closer to now than waiting till later this year when we have the remote notary town hall. So $6 per Notarial Act. Again, Notarial Act, we get asked a lot of questions about this. It is not per document. It is per Notarial Act. Every time you identify somebody, you watch them sign the document, you complete a notarial certificate for every Notarial Act for them, and then you write their information in your journal. Every time you do that, it's a Notarial Act. So if 2 or 3 people are signing in front of you and you're identifying them all and notarizing each one of their signatures, that's $6, $6, and $6, right? $6 per each Notarial Act and $25 per each remote Notarial Act. So notary journal errors, another big one here that we see. You are required by law to maintain a journal. You used to be known as a fair register of official acts. So now you need to have a journal, that's what the law calls it, of your official acts. You must have this. This is not a negotiable thing. This is not something where you can say, I don't know. I know the person, so I'm not going to bother writing it down. Or I notarize for the same person every day. Got to keep a journal for that same person every day. It is required. Each and every Notarial Act must be written in your journal. It must chronicle all acts, and you must enter each notarization of the journal. Again, even if you're notarizing for the same people regularly. But Mike, it's the law. It's a requirement. Make sure you take care of it. A lot of folks don't realize how important that journal is until something they do is called into question later. And they need that journal to verify what they did and didn't do, including notarizations that, maybe you work somewhere, you notarize each and every day for a coworker or boss or whatever, and then you leave that employer, you take that journal with you, and years later a question comes up, I was never there, you got your journal to fall back on each and every time you notarize. I've seen it happen many times. Just because all was good today does not mean all will be good with that same person tomorrow. We all know that. Not just from our professional careers, but just your personal life. Everybody knows that. So keep your record, do your job on that. You want to, again, accurately document every entry in your journal. You want to make it contemporaneously with the performance of the Notarial Act. So what does that mean? It means at the same time or occurrence as the Notarial Act. Really, you should be doing it while they're right there. If you go into our handbook, it actually tells you after you identify them, they appear before you when you identify them, to make the journal entry then and there. If you go through the checklist in order, you're making your journal before they've even completed the Notarial Act. What's the benefit of that? Say something happens and it comes up and you decide you can't notarize it. You've already got the information. You can make a note as to why you had to deny a Notarial Act. Failure to take the notary journal When leaving employment, I touched on if you're at a job and you leave, take it with you, right? Your notary seal in your journal or your property. Your employer may be paid for them and they think they are theirs. They are not theirs. I can't really get into that employer-employee relationship though and give advice on how to deal with that. I can't. But the journal is your property. The seal is your property, even if your employer pays for it. But that's the notary stuff. Take it with you. It's yours. Because again, when something comes up later, if something comes up later, your name's on it, not the company's, right? So we're going to need to contact you about that, or whoever's going to need to contact you so you can clear up what you did in your position as a notary public. Hopefully that day never comes, but it comes for many. So have your good records. And maintaining sequential pages in a single journal. So if you have a paper journal, it has to be bound in numbered pages. So the pages need to be permanently bound. The pages need to be numbered. You need to make your journal entries in sequential order, which is easy if you're doing it contemporaneously, like with the Notarial Act, as the law requires. You can't go out of order if you're doing it in order, right, and in real time. But maintaining multiple paper journals, you can't do that. You have to have one paper journal. Now, when that book fills up, obviously, you get a new journal and you start a new journal. But you can't have multiple paper notarial journals going at the same time. You fill one up, you move on to the next one. You don't have 2 or 3 paper journals at a time. And folks oftentimes forget to tell us that their journal was lost or stolen. And I realize that, if something happens, we may not be your first fault. But as soon as you realize your notary journal's been lost or stolen, reach out to us, shoot us an email to the notary division, give us a phone call, let us know that it is missing. We don't know it's missing unless you tell us. So make sure we know it's missing. Again, on the off chance something ever comes up, we know it's missing because you told us as soon as you realized it happened. So make sure you reach out to us if you ever find it's been lost or stolen. Sometimes people lose them and they find them later and they let us know. Great. Let us know that too if that happens. Certain journal requirements, you got to keep the journal for 10 years after the last Notarial Act that's in that journal. So those journals need to be kept for 10 years. Even if you're not a notary, you're still required by law to keep your notary journal for 10 years after the last Notarial Act. So that's, I got to keep that book. Yep, keep that book. They're not huge books. Now maybe you do a lot of Notarial Acts and you got a few of them, but find some space, throw it in a filing cabinet where you can go find it again. Got a desk in your home, if or in your office where you can keep that stuff safely. Where it's at should it ever need to be the case. Whatever you do, I always say this: don't keep it on your basement floor. If I have $1 for every time somebody said, God, my basement flooded and it ruined my journal, that's only ever when we're contacting them about something that they potentially did wrong. So keep your journal in a safe space, not on the basement floor. And put it in a file cabinet, put it in a desk, put it in a drawer somewhere. They're not taking up a ton of space individually. A journal's not that big. Each journal must contain certain information, and all this is laid out in the law now. Date and time of notarial action performed, description of a record, full name and address of each individual. If you're identifying an individual in personal knowledge, note that in your journal. If you're identifying somebody with an identification credential like a driver's license or passport or non-driver ID card, you want to briefly describe the method of ID. So if, say I came before you, Maryland driver's license, and my issue and expiration date and my driver's license number. I'm asking this not for you to provide me an answer necessarily, but think about to yourself, how many of you actually know your own driver's license number? I bet not many. There's always a few. That know it. But how many of you actually know your full driver's license number? Great. Required by regulation to put it in your journal. When you identify somebody using a driver's license number or passport, you write that number down in there. But think about the power of having that license number in there, right? It's indisputable if you have their driver's license number in your journal that you've identified them, right? It's there. You only know that because you looked at it, because I bet you that person doesn't know their own driver's license number anyway. So important information to keep, but not just, oh, it's a requirement, right? Everybody wants to know, I know what the law says, but that's why it's in there. That's why it's a requirement. The fee charged, if any, by the notary public. If no fees charged, note that no fee was charged, $0. We talked about fees and overcharging on a prior slide. Know your fees. Just know your fees and what you're allowed to charge. And one important side note on that I didn't think about on that slide, folks will often ask us, I'm going to throw it out now, because we get asked questions about this all the time as well. You could charge $6 a notarial act. People often ask, what if they want to tip me? Cannot accept a tip. You're allowed to demand and receive no more than $6 per notarial act, no more than 25 for a remote notarial act, no more than. So the law was worded in a way that it explains you can demand and receive more than that certain amount. So no, there's no other funny fees you can charge. You can charge a service fee, a after hours fee, an inconvenience fee, a convenience fee. Those are the fees. So make sure you note the fees in your journal. If you travel for a notarial act, might be good to break down your fee a little bit, right? I charge $6 for one act, and I charge $5 because I went somewhere, and X amount for mileage. It's good to break that down should there ever be a question. Indication on whether the individual who was subject to the notarial act appeared in person or by means of remote communication technology. So if you remotely notarize, you want to make sure you note that for that notarial act. And again, just making sure we're keeping a solid journal. And everybody says there's so much information, it's too much to write down. I don't have time for that. 30 seconds. 30 seconds. You've already identified them. You're holding your ID, write it in the journal. It really doesn't take that long. Minute to do it. Make the note in your journal. A, you're required to by law. B, this journal is your lifeline should there ever be a question. You have your records of what you did. And if you write good notes and you take the 30 to 60 seconds to do it, it'll save you a lot of headache and time in the future. A few more notes on journals. I talked about keeping a paper journal. So for all your tangible record notarial acts, so traditional notarial acts on a paper record, you need to have one journal. For those notarial acts that are performed on tangible records, it must be permanent, bound, registered with numbered pages. Electronic journals, you are allowed to maintain one or more electronic journals. They must be permanent, tamper-evident electronic format. Think about why you could have more than one electronic journal. Say you are a notary and you subscribe to 3 or 4 RON vendor platforms. Generally, as part of their platform, there's an electronic journal. So you may have one on each platform for your notarial acts done on each platform. So paper journals, only one at a time. Electronic journals, there could be more than one. That would be the reason why you would have more than one. Mistake number 5, notary stamping device errors. Again, this is a pretty simple one to get right, but folks oftentimes get confused on what really needs to be on their notary stamping device, otherwise or more commonly known as a notary seal. Failure to maintain and secure the stamping device. We talked about the journal. Just like the journal, the seal is yours. Don't let anybody else use it. Don't let anybody else possess it. It is your property. You need to keep that thing safely. Lock it in your desk if you use it at work. Keep it safely and secure if you're using it at home. It's your seal. Don't let other people use it. Don't let it fall into other people's hands. Again, many horror stories from notaries that they kept their seal on their desk at work. They didn't lock it up, and it ended up on all kinds of things they did not notarize, and they had to then go answer for that and clear their name and spend a lot of time doing that, and get dragged into other people's personal messes that they want no business involved in, being involved in. It's your seal. It's only for you to use. It has your name on it. It's yours. Other thing we see sometimes is the notary seal doesn't have the information required to be counted as a seal. Your seal could be a stamp, ink stamp. It could be the embosser, which makes the raised marks on the paper. The three things you absolutely need to have in order for it to qualify as a notary seal is your name as it appears on your commission. So if I'm commissioned as Michael Schlein, my seal needs to say Michael Schlein. Can't say Mike Schlein, M Schlein, MS. The name on my notary commission is the name that must appear on my notary seal. Second thing that must appear on your seal is the words Notary Public. The third thing that must appear on your seal is the county in which you were commissioned, or if you're commissioned in Baltimore City, you would say Baltimore City or City of Baltimore. So the jurisdiction in which you are commissioned. How do you know that? Well, that's generally speaking, if you live in Maryland, if you're a Maryland resident, it's the county in which you are a resident. You will go to the clerk of the circuit court in the county in which you reside and get sworn in and get your notary seal. If you live outside of the state of Maryland, it's most likely the county in which you are working or have some relative ties to why you became a Maryland notary. But if you're a Maryland resident, it's always going to be the county in which you reside. Or if you reside in Baltimore City, it'll say Baltimore City instead of Baltimore County. And again, if you change employment, take your seal with you. It's yours. It's got your name on it. If your seal is stolen or lost, let us know. Same thing with your journal, right? Let us know it's yours. If you realize it's been lost or stolen, reach out to us and let us know so that we know it's been lost or stolen. If anything comes up later about that, we at least know you reached out to us and when it was reported and for what that's worth. Stamping device must be capable of being copied with the record to which it is affixed or attached. Easiest to do that with an ink stamp, but there is a way to shade things if you're using an embosser with the raised impression on the paper to make it so that it can be copied. Both are general use throughout the state. Both are fine. Again, let us know if it's lost or stolen. And if you resign or your commission's revoked or you just expire and decide I'm not going to be a notary anymore, I'm not renewing, disable your stamping device. If it's an ink stamp, take the rubber stamper piece off and chop it up, right? Cut it up. The embosser is a little harder to render unusable, but render it unusable so that it cannot be used later. I've had folks, we've heard, again, horror stories about folks leaving. Maybe they leave their job where they needed to be a notary. They're not going to be a notary anymore. So they just leave all their notary stuff. 5-10 years later, that notary still showing up on documentation that they're not even notarizing. And again, whose name is on that? It's your name that's on that. So make sure you secure it. Make sure you take it with you. Make sure you're the only one that can attach it to something. And if you decide not to be a notary anymore, destroy that seal. Get rid of it. Mistake number 6, talking about in-person notarizations. You always, if you're in person, the person has to show up before you. They have to be there when you're notarizing, right? You have to identify them in one of those ways, regardless of the type of notarial act being performed. Personal appearance for your traditional notarial act is required. All the time, folks will say types of notarial acts are listed, but the point of this is just because you know them doesn't mean that they don't have to show up before you. Just because you know them and they need a favor for a friend, you still have to show up before you. Still got to show up before you. You still have to identify them, whether it's ID or personal knowledge, each and every time. Always requiring personal appearance, always identifying the person requesting the notarial act, and always keeping a good journal entry. Folks will call us, it's a friend, they really need a favor. Their spouse is hurt right now and they can't make it to me, and they're just trying to get something notarized. Can I do it? No, not unless they're appearing before you. But they're my friend, and well, if they're your friend, they will understand what your job is, right? Your friend will understand, your family will understand that you need to follow the law. If they're your friend, they're not going to put you in a situation knowingly that requires you break the law or do something you shouldn't do. Right? Your friend's not going to make you do that. If they're pushing you to do something you shouldn't do, don't do it. Right? Don't do it. They're probably not a very good friend if they're demanding that of you and trying to put a lot of pressure on you. That tells you something's probably wrong. So always requiring personal appearance, always identifying signer, always keeping a journal for in-person notarial acts, for remotes as well, but speaking specifically in person where the person has to come to you or you have to go to them. If they've come to you, you may as well make sure the right person's before you and the right person is signing this document. You're completing the notarial certificate for the right individual that actually needs the notarial act done for them, not for some third party that's just running it to you. Always identifying signer, always when required witnessing signature, or having the person attest to the fact that they signed it while they're before you and that document and all is in your presence. So again, just traditional in-person notarization must always be in person, right? In the same physical presence of the person requesting the notarial act. If I tell you my friend needs something notarized and I'm the one standing before you and not my friend, you can't notarize it for me. I'm not that person that's requiring or requesting the notarial act. I'm requesting it for them, but I'm not the person for which you're conducting that notarial act. Identify the signer using a valid government issued photo ID. Again, you got personal knowledge if you know the person. Credible third-party witness is there if you need it. Witness the signing of the document, or if they need to attest to it, they can attest to it if it's already signed. Affix their seal, execute the notarization, enter the official act in the journal, right? Always, each and every time that notarial act is happening, the person who is signing that document before you, requesting the notarial act, it's all happening in person at the same time. Identification is completion of the notarial certificate, execution of the signature, execution of your notary journal. It's all happening at the exact same point in time at which that notarial act is being performed. Electronic notarizations, not to be confused with remote notarial acts. Electronic notarization is really the electronic signature, but still in person. So your in-person rules would apply, except for the fact that you may be electronically notarizing an electronic signature. Go back to that for one more second. Is again different than remote notarial acts. So electronic notarization still requires physical presence. Remote notarial act is what you can do when you identify somebody remotely through use of communication technology. Remote notarial acts tend to be electronic. Not all of them are. Again, you'll learn more about that in the remote notarization town hall. But electronic notarization still in person. It's just with electronic signature. Notarial acts within the state of Maryland. Notary public may perform notarial acts in any county of the state or in the city of Baltimore, regardless of where you are commissioned. This is also a frequently asked question we get. I'll give a couple examples here. Say I'm here from Annapolis, that's where our office is. Say I live in Annapolis. Maybe I've gone on vacation down at Ocean City and I took my notary seal with me and somebody needs something notarized. And here I am with my notary seal to notarize for them. But I'm commissioned in Anne Arundel County. Can I notarize in Ocean City? Absolutely. Anywhere in the state of Maryland, regardless of where I am commissioned. Say I'm from Baltimore. I'm commissioned in Baltimore City, but I'm down in Rockville or Upper Marlboro or out in Cumberland, wherever, and I need to notarize something. Can I notarize it? Yes, absolutely. You're a notary for the state of Maryland. You were commissioned in Baltimore City. You can still notarize anywhere in the state of Maryland. So no matter where you're commissioned in Maryland, you can notarize anywhere in Maryland. It does not have to be only in the county in which you're commissioned. Any county or Baltimore City in Maryland, you can notarize in. However, being a Maryland notary does not authorize you to act as a notary in another state or in the District of Columbia. So if you're a Maryland notary, you can't drive to DC and notarize. You can't drive to Virginia and notarize. The notary must be physically present in the state of Maryland to act as a Maryland notary public. Now, could you become a notary in DC or Virginia or Pennsylvania or Delaware? Sure, absolutely, according to their laws. But you would get commissioned by them to act in their state. If you're acting as a Maryland notary, you must be physically present in the state of Maryland when you are notarizing that document. Even if you're acting as a remote notary, you still must be standing in Maryland, right? Your jurisdiction as a Maryland notary begins and ends in Maryland. So make sure you're in Maryland when you notarize. Again, anywhere in Maryland is fine, but in Maryland. A notary can notarize documents from or for another state as long as the document is notarized in Maryland. Maybe somebody's on vacation, they're visiting from California, and they're here in Maryland visiting somebody. Something happens, emergency happens, they need to get something notarized. Can you notarize it for them? Sure, you're in Maryland, right? You're in Maryland when you're notarizing. It doesn't matter where they're from or where the document's from or where it's going. You're a Maryland notary. You can notarize it if you're in the state of Maryland. To try to run down all the scenarios we get asked a lot about there. Bottom line is Maryland notary can notarize when in Maryland. Can't take your Maryland commission and go elsewhere. But people from elsewhere could be here and have you notarize. So again, different types of notarial acts. There's a whole town hall about types of notarial acts. We did it back in May. The recordings on our website too that talks about all these types of notarial acts and the certificates that go with them. It's all covered in that town hall. Conflicts of interest. So you're a notary public, right? You should be a disinterested third party for anything you're notarizing. So you want to avoid actual or even just perceived conflicts. Avoid performing notarial acts in which you are a party for family members or other conflicts of interest. You may not perform a notarial act with respect to a record to which the notary, you yourself, the notary, or your spouse is a party to, or in which either the notary or their spouse has a direct beneficial interest. A notarial act performed within, violation of this is voidable. It's what the law explains. Can't notarize for yourself. Can't notarize for your spouse. Those are your legal duties for refraining. Those are the individuals for which you must refrain. Can't notarize for yourself or your spouse. However, just because you're not under a legal duty to refrain doesn't mean you should go run out and notarize for every other member of your family. It's a bad idea. I don't have that exact percentage, but in my days as an investigator for this office long ago, when I dealt with notary complaints, I bet you about half the complaints I've received involved family relationships between notaries and signers. I mentioned earlier, everything is good till it's not. We all love our family, and but if you watched any TV show ever, you know that sometimes families have problems, families fight, families disagree, and sometimes things can get ugly. Again, it's all good until it's not. So there's about 90,000 notaries in the state of Maryland. You can find another notary that's not related to you. Get somebody that's not related to you to do the notarial act for your family member. Folks often will shrug off that advice or that thought. Again, not legal advice, but just friendly thought for you. Get somebody that's not a notary, that's not a family member to notarize for you. If you're the notary, don't notarize for your family, your siblings, your kids, right? Stay away from it. Everything is good there until it's not. You'll thank me later if you listen. Matters in which the notary is personally involved, even if indirectly or where there's no beneficial interest. So maybe the notary has some level of involvement in something, even if it's indirect or you may not get a beneficial interest. Best to stay out of it. Again, there's a lot of notaries. You can find someone else. Talking real quick, let me go back to this slide for one more second. The one exception that's carved out in all this is notary, right, for your employment. A lot of folks become a notary because their job wants them to. Maybe you work at a bank and you have a customer, you need to notarize some documents for the customer, for the business of the bank, and you're an employee of the bank. Of course, you can notarize those documents. You may be the employee of the bank, you're notarizing it for a customer, for other bank business, or even maybe your boss or something like that. That is okay to do. You don't have to go outside of the company to get a notary. However, we do get asked on occasion, well, it's husband and wife company, but you can't notarize for your spouse, right? So you can't notarize for your spouse. That is a hard no. no matter what. Exceeding the statutory authority of what a notary is allowed to do. I'm going to focus a lot on these first parts here. I even began our presentation talking about how this is for informational purposes and can't be taken as legal advice. The notary doesn't have the ability to give legal advice or draft legal records or otherwise practice law unless they are licensed to practice law. So if you're a notary who's also an attorney, great. You're a notary who's under the supervision of an attorney, great. You're acting on that attorney's supervision. But if you're not an attorney or under the supervision of an attorney, shouldn't be giving legal advice, shouldn't be practicing law, shouldn't be helping with drafting legal records. Simply being a notary also doesn't allow you to act as an immigration consultant or expert in immigration matters. Again, if you have the credentials or the authorization or license to do that stuff, great. That's independent of being a notary. You may be somebody that can do that who also happens to be a notary. But if you're just a notary public, that doesn't authorize you to do these things. Can't represent people in judicial or administrative proceedings relating to immigration or citizenship or other related matters. Again, if you're an attorney, go ahead, right? You're an attorney, you're allowed to do that. But if you're not an attorney, you're regular notary public, you can't be doing this stuff. And if you're a notary public who's not licensed or otherwise authorized to do the above things, can't be taking pay for doing those things, right? So if you can't do them, you certainly can't get paid for them. So if you want to practice law or give legal advice, become an attorney. Don't just become a notary, become an attorney. Again, there's some other terms here, notario, notario public, notario publico, that can be deceptive. You can't engage in false or deceptive advertising, and you can't advertise or represent that a notary may assist people or give legal advice. So you can't advertise yourself as somebody who can give legal advice. As a notary public, you need to be the attorney in order to do that. And the number 10 here, failure to affix a notarial certificate. Save another big one here. We led with the big one. We're going to end with the big one. Failure to affix the notarial certificate. Prior to October 1st, not all notarial acts required a certificate. As of October 1st, 2020, the law requires a certificate.
I think I'm done. I'm done.
If you can mute yourself there, please. The law requires that the certificate is completed for each notarial act. If the certificate is not included on the record being notarized, a notarial officer is required to affix the notarial certificate. Different types of acts require different certificates. There's a bunch of examples of certificates in our handbook. They're also just in the law. Examples of what a certificate must include at a minimum is in the law. So each type of notarial act has a certificate that goes with it. Again, the town hall for May covers a lot of that information. And you need to know what is being asked by the person requesting the notarial act in order to affix the correct certificate. So certificates are now required, and each certificate has to be, or each notarial act must be evidenced by a certificate and be executed contemporaneously with the performance of the notarial act. Signing, right? Somebody's going to sign the document that's being notarized. You're going to notarize their signature. You're going to complete the certificate. The certificate has to identify the jurisdiction. So always state of Maryland, right? Because you're always in Maryland. And then the other thing is going to say county of or city of, and that's where you're located, right? We all know, I gave the example of being commissioned in Baltimore City earlier and notarizing down in Rockville. If I'm a Baltimore City notary, it's my name, Notary Public Baltimore City on my seal. The certificate, if I'm standing in Rockville, is going to say state of Maryland, county of Montgomery, because that's where I'm at. That certificate is telling the story of what is happening at this point in time where you're notarizing. So think of that certificate as kind of telling the story on the document. Who is signing the document? Where are you when it was done? On what day is it? What is it that's being notarized, or what type of notarial act is it that's being done? And who the notary is completing the notarial certificate and notarial act. That's all in the certificate. That certificate needs to be completed each and every time. And again, just you don't sign the Notarial act until you've completed that certificate, you've identified the signer, and if it's a thing that requires it to be signed in front of you, you watch them sign it, where they acknowledged or attested to their signature, depending on the situation. If it's an electronic record, right, same stuff. You're going to still sign in a fixture seal. It's likely going to be an electronic signature and seal, though, and it's going to be affixed or logically associated with that electronic record. So thinking remote notarial acts for that type of thing. So we're going to get to the questions here, and I'm also going to make sure I put our contact information up here. If you have something you don't really want to ask us here, or maybe you didn't feel comfortable putting in the chat or asking on this meeting, by all means, reach out to us by phone or by email. It's DLNotary_SOS